Welcome back to the channel. Now that I've gone through a couple of solutions for the ITSM operations, I want to move on to solutions that I've come up with for the legal sector. Now, while putting together this video, I was doing some research and I came across this actual court case, which is interesting. So what's happened here is that we've got, and this took place, last year, so 6th of June, okay? And if I go down to page 4, go back down a little bit more. Okay, so section 14. What happened was you have two lawyers. They used ChatGPT to identify relevant case law. So one prompted the tool to draft a court submission, which they submitted verbatim on behalf of their client. However, the AI generated legal analysis that was faulty and contained fictional citations. The AI output was entirely fabricated, falsely attributing nonsensical opinions to real judges and embellished with further false citations and docket numbers held by actual cases irrelevant to the matter at hand. Okay, so in a nutshell, you have a client that's paid for services from a law firm. These lawyers use ChatGPT to build the case on behalf of the client and clearly submitted it without checking it. Now, the reason why this happened in the first place is because this law firm had 9 gaps within the firm, okay? And what I'm going to do over the next few videos, broken down into 10 modules, is to articulate what those 9 gaps are and how you can fill those gaps. And I'm going to add some extra value as well. I'm going to provide some templates for each gap that you can take away and obviously adapt to your business. Now, I wanted to do this in such a way that you as a viewer can resonate in that sense. Okay, so how I've done this, I've created a scenario whereas we've got a fake law firm, and this law firm is called Halstead Cole LLP. They have an annual turnover of about 8.2 million. They have 90 fee earners being those individuals that actually charge clients for their expertise. Okay. Their regulator is obviously the SRA, Solicitors Regulation Authority. Their biggest client is Pemberton Capital LLP, and they generate for the law firm roughly about 600 per year. Now, the compliance officer, the COLP, is a lady called Priya, and the actual managing partner is Jonathan. He has his name above the door, Jonathan Halstead. Now, when it comes to their governance status with regards to AI management systems, they have no documentation. Now, one thing I want to be clear is if you're a law firm and you have fee earners or anyone within the business actually using AI to optimize their work, so to speak, help them draft emails or whatever it is, and you have no actual documented AI management systems at all, then this applies to you. This scenario applies to you. Okay. And what I'm going to do is, purpose of this module is to break down what those gaps are and how to close that gap. And that's all before you actually flick the switch to enable any form of AI to be used within the business. All right, so let's just get a little clear picture with regards to this scenario. Now, let's talk about the 4 main characters within this scenario under the law firm. Again, we have Priya. She's the COLP. She's the compliance officer. You've got Jonathan Halstead, the managing partner. We've also got a Marcus Webb. Now, he is the head of IT for the firm. And then we got Sophie, who is the paralegal. Now, for Priya, because she's the COLP, by default, she is the AI risk owner. Okay? By default, based on her title. So Priya has inherited, and this is under the SRA rule 9.1, Priya has inherited every AI exposure the firm currently carries by default, because no one else has been named as being responsible, basically. Okay, you've got Jonathan. Now, his signature on every AI deployment is needed. So Jonathan approved the rollout of GPT 4.0 and Microsoft Copilot across the firm without a policy, a register, or a system owner. Okay, so under the ISO clause 5.2, leadership commitment is a mandatory evidence-based control, and the absence of that evidence is the most acute government gap in the firm. So bear that in mind. When it comes back to this actual court case here, the managing partner of the law firm clearly enabled, signed off, whether it's Copilot, in this case, it's obviously ChatGPT, to be used within the firm without any form of evidence-based control. Okay, we move on to Marcus Webb, who is the head of IT. Now, he owns the technology, okay, not the governance. So Marcus will manage the licenses, the integration, the access controls. Now, he's completely unaware of his IT governance obligations under the ISO clause 7.5, system register, and the clause 8.4 when it comes to supplier governance. The technical controls he runs every day are unmanaged from a compliance perspective, right? Then we come down to the paralegal. So this is Sophie Chen. Now, she is the end user whose unsupervised AI exposure defines the firm's frontline risk. So in the case of this example, this is actually a real case, but the two lawyers, so if I go back down to page 4, I believe it was. Yeah, so these two lawyers, whoever they are, these two lawyers were unsupervised in terms of how they use ChatGPT in their business. All right, so those are the characters. Let's dig into the scenario. So you have Priya. I've put here the first thing Priya did after reading the SRA thematic review was open her firm's intranet and search for AI policy. Nothing came back. The second thing she did was ask Jonathan, so that's the managing partner. So she asked Jonathan, and he said he assumed IT was handling it. So Marcus Webb, head of IT, Marcus said, I assume that the COLP was handling it, which is Priya, who's asking the question. Nobody was handling it. The firm had been running ChatGPT 4.0 for 10 months. Okay, so that's the narrative. Now, when it comes to the SRA thematic review, I've also got that here. I scroll up to the top. So this is the report here on the Solicitors Regulation Authority website. And this was from the 11th of December last year, 2025. Now, they visited 25 law firms and they spoke to 36 individuals, and they reviewed compliance policies, internal breach logs, and learning and development records. Now, under here, they've I don't believe this is the detailed report. I believe this is a summary, but it does hold very, very interesting information here. For example, it goes on to say, in terms of firms, so law firms must maintain records to demonstrate compliance with their regulatory obligations. This include compliance officers who are to record all breaches that occur and make appropriate notifications to the SRA. Now, what they found was that a fifth of the compliance officers that they spoke to could not explain their record keeping obligations, while only half had read our report and notification guidance. Only one individual was able to describe the difference between a notification, which must be reported to us, i.e. the SRA, and a report, which is circumstances that may have been reported but allows the CLPs, the CO or the COFA's discretion. That in itself is a clear problem. To actually go out and speak to 25 law firms, 36 individuals, and only one individual was able to describe the difference between a notification and a report tells me, as the reader of this report right now, that law firms have a problem. So, when it comes to AI adoption within the law firm, you do need AI management systems. And the purpose of this is that every system below is live and nothing is documented in any register. There's no system owner. None has been subject of a risk assessment. data protection impact assessment, or a supplier governance review. So this is the firm's before picture. The 9 gaps are measured against. Okay, so right now we scroll back up here in the top. This is the actual state of this demo, this fake law firm that we're using in the scenario. They have no documentation for AI management systems, but they are using Copilot and ChatGPT 4.0. So let's look at the actual gaps here. So we've got OpenAI. The law firm is using this for legal research, drafting, and case summary generation. And the primary user is Sophie Chen, which we've identified as the paralegal. Okay. And again, the end user who's unsupervised exposure to AI, and she's generating legal research, drafting, and case summary generation. All right. So it's Sophie Chen, and the dispute resolution team is using this. In terms of the status, that's unsanctioned. They also have Microsoft Copilot with the 365. So they're using that for email drafting, document summarization, and calendar drafting. Now, all fee earners, so all paralegals, solicitors, barristers, have access to the Copilot because it's part of their Hotmail and Word, etc. And they're able to use this freely for these things that I've mentioned here. Again, unsanctioned. Now you also have Leap AI, which from what I looked at is an AI platform specific for law firms and for billing, narrative generation, time recording, etc. Again, all fee earners. And let me just remind you, fee earners are those professionals within law firms that charge clients their time for their expertise. And the use of Leap AI in this scenario, unsanctioned. Then you have browser bookmarks and personal prompts, Haddock prompt libraries held by individual fee earners. And all that means is as these individual paralegals, solicitors, etc., are using AI, putting in their own prompts that they come up with and saving them so that they can reuse them. There's no actually quality control or anything like that. So all fee earners are actually using prompts unique to those individuals. And in terms of the status, the prompts are unrecorded. Okay. Now, the SRA's existing code of conduct rules is competence, that's in section 3.2, supervision, section 3.3, confidentiality, section 6.3, client information, section 7.1, and the COLP accountability, which is section 9.1. All right. Now, already apply to AI use at Halstead Cole. So the absence of written AI policy does not suspend those rules. It remains the firm's ability to demonstrate that those rules have been honored. Again, competence, supervision, confidentiality, client information, and the accountability by the COLP. Okay? So regardless of any documentation, the SRA are still holding Halstead and Cole, in this example, in this scenario, responsible for upholding those rules. All right? The gaps in this module are the difference between the rulebook the SRA expects the firm to operate under and the rulebook the firm actually has. And that's the purpose of these modules, these 10 modules that we're going to go through over these series of videos. All right. Now, let's talk about the trigger. Now, when we say the trigger in terms of this scenario, so you have Priya, she opens her emails on a Monday morning and reads 2 documents that change her working week. Each one maps to a separate category of exposure within the law firm and Cole. The first is the SRA conduct risk, and the second to the court process risk. Together, they make clear that the firm's current AI usage is incompatible with the regulator's expectation. All right. So again, we've got the SRA thematic view. I've put in here where most COs cannot outline their AI responsibilities. So the SRA's thematic review of the compliance officers found that the majority of COLPs in the sample could not outline all of their responsibilities, The reviews specifically call out technology adjacent obligations. Now, Priya reading this recognizes herself in this findings, okay? Because she knows that Copilot is enabled throughout the business. But as we stated here, when asking the question, so she asked Jonathan, the managing partner, do we have an AI policy? And he was like, I'm assuming IT is handling that. Went to Marcus, and Marcus was like, I thought you was handling that. Then clearly Priya understands that she is part of this finding that's come from the SRA's thematic review. All right. So the SRA expects that the COLP to understand the firm's full risk, including the AI tools the fee earners are using without supervision. So Priya needs to know what Sophie Chen is actually doing and the output she's getting from ChatGPT, Copilot, as well as the Leap AI. Okay. The SRA holds her responsible for that. So that's the first, call it, trigger. So the second trigger is the court case. Court case I mentioned earlier, where you had two lawyers, I believe. Let's go back to page. Yep. Two lawyers using ChatGPT, and they used and submitted the documentation with 18 fabricated citations. So Priya is reading this, and she's concerned as to what is Sophie Chen using ChatGPT for daily. She understands that the firm has no prompt logs, no output reviews, no system capable of telling her whether their own work contains hallucinations. So those two things set alarm bells ringing for Priya, considering the SRA is going to hold her responsible for all of it. For all of it. Anyway, so that is alarm bells ringing in Priya's mind right now. Okay, the hallucination Priya cannot rule out. Halstead Cole has no prompt logs, no register of AI generated outputs. There is no procedure for verifying an LLM's citations against the primary sources. There are no record of which matters used AI generated research. The firm therefore cannot today look Priya in the eyes and confirm that none of its current caseload contains a fabricated citation. Now, that court case defect could already be present in the work of Halstead and Cole has already filed. This is not a future risk. This is an open exposure right now for Halstead and Cole. Okay. Now again, if this scenario of this law firm, Halstead and Cole, resonates with you as a managing partner or even a COLP within a law firm, and you know that the business is utilizing Copilot, but yet there's no documentation, this should be a huge concern for you. Okay, so 5 days after actual CRA thematic review, the firm's largest client sends a procurement questionnaire. It's not a regulatory document, it's a revenue document, and Halstead & Co. cannot answer it. So what are we talking about here? All right, so Halstead & Co.'s biggest client, which is Pemberton Capital, and they generate about 620,000 a year revenue. And Halstead & Co. deals with real estate finance and portfolio refinancing for them. Now, the questionnaire that Pemberton Capital has sent to Halstead is an AI governance due diligence questionnaire. This questionnaire asks 3 questions to Halstead, which they can't actually say yes to right now. First question, does the firm have a documented AI policy? All right, so the client procurement team wants to see an AI policy signed by leadership, so signed by Jonathan, the managing partner, and the firm has none. Priya drafts a holding response, and Jonathan is asked whether to commit to a deadline. The default answer today is no. And procurement language is increasingly common in the 26 panel agreements. All right. So this actual scenario will be growing in this day and age of AI and businesses adopting AI within their business. When it comes to especially law firms, clients are going to want to know whether there's an AI policy in place, and more than likely what that AI policy is. Now, second question. Does the firm maintain a register of the AI systems in use within the firm? So, Pemberton wants evidence that the firm can list every AI system touching client data. They want to know its vendors, they want to know its data classification, its review status. Now, Marcus, who's the head of, he could produce the list of licenses, but no AI system register exists. The procurement team interprets the absence as a governance immaturity and not an admin gap. So this is more of a governance immaturity and not an administrative error or gap, rather. Okay. The final question is, does the firm operate a documented human-in-the-loop review for AI outputs? That should be for all AI outputs. So Pemberton wants the procedure, so they want to know what the procedure is in terms of where does the human step in before it's delivered, as in submitting to the courts, for example, and the firm does not have one. So Sophie, the paralegal, her daily ChatGPT 4.0 usage has no documented review step. The honest answer to Pemberton's question is, we have not formalized this. Pemberton's response would be, if the answer does not change, is to begin a panel review. So let's look at this from Halstead and Cole's position based on this questionnaire. Their biggest client, Pemberton Capital, generates them a steady £620,000 a year revenue. Okay, so it accounts for 7.6% of Halstead and Cole's annual turnover. Now, losing the panel is not a paper cut. It is a material revenue event for a mid-market firm. Losing a client like that will be hugely impactful for a mid-market firm. Now, the procurement questionnaire is becoming standard market practice. So law firms are going to start receiving, if not happening already, but more and more law firms are going to be receiving inquiries like this from their clients, especially their big ones. And the deadline the firm faces is not a regulatory one, it's a commercial one. So the ISO 42001 controls that close the gaps in this module are the same controls that answered Pemberton's question. All right. So as we're going to go through these modules and understand what the gaps is and how to close them, they will address these questions that law firm clients, in this case Pemberton, asks. So does the firm have documented AI policy? Does the firm maintain a register of AI systems in use? Does the firm operate a documented human-in-the-loop review for AI outputs? This module will close those gaps for you. Now, the 5 gaps that block ISO 42001 certification. The critical gap means intermediate regulatory exposure for the firm and a hard blocker at certification. Right, now we're going to touch upon the critical gaps. And these are 5 gaps that block the ISO 42001 certification. All right, so we have gap 1, and that's the AI policy and management direction. So you've got AI policy. So in this case, in terms of the scenario, you've got Jonathan Halstead, managing partner. He's gone and approved the rollout of ChatGPT and Copilot across the firm without a written policy. So there's no documented statement of acceptable AI use. There's no prohibited use list, no signature from leadership, no firm level position the COLP can point to. Every other governance control is optional in practice until this document exists. Right? So gap number 1, an AI policy. Now, when you want to look at the story, how did the managing partner make this decision? So 6 months ago, Jonathan approved the rollout and he sent an email to all the fee earners. There was no policy attached, there was no register, there was no system owner. The email now is the most consequential technology decision the firm has made this year, and the only evidence that it happened is an Outlook message. That's it. That's the only form of evidence with regards to them rolling out an AI model. In this case, is ChatGPT. All right. Now, clause 5.2 requires top management to establish an AI policy that is appropriate to the purpose of the organization. So this provides a framework for AI objectives. It includes a commitment to satisfy applicable requirements and commits to continual improvement. Now, the annex control, so that's 8.2, requires the policy to be documented, communicated, and available to interested parties at all times. So Jonathan just making a decision to approve the rollout of ChatGPT and just saying a company-wide email saying, here you are, knock yourselves out, goes against the clause, the 5.2 clause. Now, when it comes to the SRA Code of Conduct rule and the Rule 2.1 and Rule 9.1, Rule 2.1 requires the firm to have effective governance structures, arrangements, and processes. Rule 9.1 requires the COLP to take all responsible steps to ensure compliance. That's their responsibility under the eyes of the SR. Okay? The COLP, so PRIA in this scenario, to take all responsible steps to ensure compliance. An undocumented rollout decision is, in regulatory terms, an unmanaged technology program, and reasonable steps cannot be evidenced without a signed AI policy. Okay, I hope that's understood. Now, as the firm has no policy on acceptable AI use, no position on prohibited activity, for example, uploading client documents to an AI model, no supervision expectations, no sign-off requirements, fee earners infer what is allowed from the absence of any rule. So Sophie Chen's daily use of ChatGPT is therefore either endorsed or tolerated. Neither position can be defended by the firm against the rules of the SRA. Now, the fix is simple. Put in place an AI policy. So the firm's first control document under the AI management system sets out the firm's commitment to responsible AI use, the permitted and prohibited use case, the human in the loop principle, the data classification rules, the disclosure obligation to the clients, the incident reporting procedure, and the named accountable officer. The policy is then signed by Jonathan, as he is the managing partner, or what I've written here is senior partner, and countersigned by Priya herself, who is the COLP, as she'll be enforcing and doing all the reasonable steps to ensure that this AI policy is being upheld within the firm. Now, I've got a free template for this. Let me just show you what that looks like. So, simple template here sets out the classifications and the owner of the document, and then we scroll down. We've got the reference to the different standards, the terms. These are things that I'm talking to law firms. You know what this is. But the key thing here that I want to show you within the template is we've got within the AI policy statement, we've got commitment to responsible AI use, the acceptable AI use cases, prohibited AI uses, human oversight, and this is a non-negotiable requirement, AI disclosure to clients, review cycle, and policy ownership. Now, the actual content under these headings, you know best how to reword them so that it's appropriate for your law firm. But I have put this information in here to give you an understanding of what types of information goes into the different sections of this policy. So when it comes to the scope, the policy should apply to all members of staff. You've got sections here where you'll put your law firm, etc. All parties acting on behalf of the law firm and so on. And then we've got the responsibilities section. So you've got the managing partner, who is the approver for the policy and all amendments. You've got the COLP. In the case of the scenario, that's Priya. And she maintains this policy, conducts annual review, communicates changes, monitors compliance, and reports to the senior leadership. That closes the loop. Okay. Then you've got the head of IT. Head of IT maintains the system, so it ensures only approved AI systems are accessible. based off the policy, and reports new AI developments to the COLP, so that'd be PRIA, so that this information can then be reported back to senior leadership. Again, closing the loop. You have the responsibilities of all the free earners. So that would be Sophie in terms of the paralegals. So they shall comply with this policy and should report suspected breaches or AI incidences to the COLP immediately, which is then reported back to senior leadership, closing the loop. And then you've got the supervising solicitors. They shall oversee AI use by supervised staff. They shall review all AI assisted work before external communication. So this AI policy is to clearly document the responsibilities of the AI use throughout the firm. All right. Now, this is not active until this is signed by the COLP, the managing partner. All right. So this is the actual template that I've put together so that you have a broad idea in terms of what information needs to go into that policy, and you will update accordingly. At the end of the day, you guys are the legal experts. Okay, so going back, like I said, there's a free template there, which is downloadable, and it contains the standard policies sections, the sign-off block, the revision history field, etc. Again, I've just put in here as a disclaimer, this is a template, so it should be reviewed by a qualified solicitor before adoption, and it's for educational purposes, and I'm not giving legal advice here. All right. Okay. Now, that was gap 1. Gap 2, internal organizations and roles. So the roles and responsibilities register. So Priya, as the COLP, she holds every AI risk accountability by default. See, there is owner. There is no AI system owner for any tool. There is no human in the loop reviewer designated for any practice area. The entire firm's AI governance rests on her shoulders. This is the most fragile operating model in SRA's regulated firm can have. This is the most fragile, because the obvious thing is, what happens if, and I talk about it later on, what happens if Priya goes on holiday or is sick, for example. So I've broken down this gap 2 into a couple of sections. So Priya is the single point of failure. One person, every risk, no backstop. So as Priya, like I said, is the COLP, she is also the default AI risk owner. She's the default AI system owner for every tool in use. She is the default data protection reviewer. She's the default incident responder and the default human in the loop reviewer. If she's on leave for 2 weeks, no AI governance decision can be made. If she resigns, the AI management system has no continuity. The firm has built a one-person control structure for a problem that crosses every practice area and every system. Priya has a lot on her shoulders when you don't have the actual systems in place to adopt AI properly. Now, what does the ISO 42001 require? Okay, so it requires roles, responsibilities, and authorities shall be assigned and communicated. All right, so you got the ISO IEC on clause 5.3 requires roles, responsibilities, and authorities to be formally assigned and communicated. Now at Halstead Cole, this means naming a AI risk owner, AI systems owner, one per tool. So in this case, one for Copilot and one for ChatGPT. They also require a AI management system program lead and a human in the loop reviewers. At the moment, nobody has any of these titles. Because of that, Priya, as the COLP for the firm, holds all that risk. Okay, now what fixes this is in module 2. So we'll cover this in the next video, module 2. And what fixes this is the AI management system document. Okay, and what CI stands for is responsible, accountable, consulted, and informed. We will cover that in module 2. Okay, moving on. The SRA Code of Conduct Rule 3.3 and 9.1. 3.3 requires managers to ensure adequate supervision. Rule 9.1 requires the COLP to evidence reasonable steps. A single individual accountability model cannot evidence either. There is no documented second line of defense. There's no documented escalation path, and no evidence that any AI decision was reviewed by anyone other than PRIA. Now, the SRA Standard and Regulations 2019 expects the firm to demonstrate that compliance responsibilities are distributed and that supervision is operative and not theoretical. Now, the gap in this scenario is that the firm has not defined who owns the AI risk, who owns the AI system, who reviews the AI outputs in each practice area, who reports AI incidents, and who signs off on new AI tool deployments, or even who reviews AI model updates. Every one of these decisions default to PRIA as the CLP by default, just because of her title. And defaults that are not documented do not exist for so purposes. So the concentration of the risk on a single individual is, in audit term, a single point of failure that no firm can defend. So there's no excuses. Now, when it comes to the RACI, which is again responsible, accountable, consulted, and informed, when it comes to the AI management system documentation, it assigns named individuals to each AI governance role. So you will have, for example, the AI risk owner, that's Priya. You have the AI system owner per tool, that's Marcus for infrastructure, named partners for practice areas tools. Okay. Then you've got human in the loop reviewers per practice area. You have incident reporting lead. You have a document controller. The responsible, accountable, consulted, and informed documentation is signed off by the senior partner and is the second control document in the AI management system, call it portfolio or document register. It converts the firm's implicit accountability model into an explicit, auditable, signed off, ready structure. All right. That's the fix for gap 2. The responsible, accountable, consulted, informed AI management system document. All right. Now, in module 3, we're going to build that actual document. So we've got to build that document. We've got to name the role holders and define the escalation point. And again, I also have a template for that. I have a template for each module. All right. And we'll go through that. Now, if you haven't gathered already, each gap that we're talking about now is going to be a separate module that we're going to go through and break down. And at the end of that module, where we talk about that gap, we'll have the actual template. Okay. So coming back here, we've got gap 4. And gap 4 is the risk and impact assessment. Now, the firm has never assessed the risk of using AI. So they've never looked at hallucinations, fabricated citations, biased outputs, privilege waivers, data leakage, etc. None has formally been identified, scored, or even treated. So the firm operates AI tools without knowing the size of the risk surface it is standing on. So when Pri is asked by Pemberton Capital to describe the firm's top 3 AI risks, she has no idea. She can't answer that question. The firm has no AI risk register. She has nothing to refer to. The firm has never scored the likelihood or impact of an AI-related incident. So the firm has no documented risk treatment plan. And its answer is, we don't know what we don't know. And that is just not good enough. So what does the IN1 require? All right. Clause 6.1.2 requires the organization to assess AI risks, considering the likelihood, the impact, and the effectiveness of existing controls in terms of how you would defend against these impacts. Okay. Then you've got clause 6.1.3, which requires the organization to determine and apply risk treatment options. So the Annex A, Annex A 8.5 requires a structured, documented AI risk assessment process with defined criteria. Right? That is what 42 2001 requires. Now, what SRA rule requires, along with the UK GDPR, Article 35. Now, the SRA rule 1.2 requires the firm to identify and mitigate risks to their clients. The UK GDPR Article 35 requires a data protection impact assessment, where processing is likely to result in a high risk to the rights and freedoms of natural persons. Automated decision making and large scale processing of client data by an AI tool clearly triggers this. The absence of both assessments is a current breach. Hence, this court case where you had a law firm submitting documents to court that had fabricated data generated by AI. Okay, this is again an actual court case in the London Borough of Haringey that took place in June last year. So the absence of both assessments is a current breach. Okay, now you've got the gap in the scenario. So the gap in the scenario is that Halstead Co. has not assessed the risk of having any fabricated citations in court filings, which in real life causes this court case. You've got B, the bias risk. So is the outputs showing any discrimination towards employment or property work? You've got the privilege. So privilege waiver risk. So uploading client data documentation to a commercial LLM for review, or to asking, a common one is to asking AI to take out key points, for example. You've also got the data protection risk. So international transfers without valid mechanisms. So none has been scored and none have a treatment plan. And this is the gap scenario that Halstead and Co. are currently in as we speak, going through this module. Now, the fix for this is a risk and impact assessment register. Now, this document will identify the AI risk, its likelihood, its impact, its inherent risk score, the existing controls, the residual risk score, and the agreed treatment plan. So accept, mitigate, transfer, and avoid. The register is reviewed quarterly and is the third controlled document in the AI management system. Once again, I'll provide a free template for that as well. Let's go into gap 6. So you have the data governance and confidentiality. Now, client data is being transmitted to a commercial AI API. For this case, in terms of the example, it will be ChatGPT, Copilot, and Leap AI. Now, this is done without any proper data transfer mechanism. So without a signed data processing agreement and without a documented classification of what client data can and cannot be submitted. This risks waiving legal professional privilege. And this is an exposure that no firm can survive. All right. This comes out, Halstead and Co. are in serious problems. So you've got Sophie Chen. She has ChatGPT 4.0 open in her browser next to a client matter file. So she pastes the paragraph of the client correspondence and asks ChatGPT to summarize this for the partner. The paragraph contains the client's name and the substance of their dispute. By the time Sophie closes the tab, the text that has traveled to the US-based commercial API has been logged in AI's infrastructure and may now form part of the model's training data or future retention. Privilege may also be lost. So let's just think about that, right? You've got Sophie in this example, in this scenario, who's a paralegal. She has a client matter, and she has basically used ChatGPT to summarize some information that the client has given to her. And now the information she copied and pasted into ChatGPT contained the client's name and intimate detail about the dispute. That information sits in the US. So the UK GDPR, that's what can I say? Now that's sitting on OpenAI's infrastructure and is used for model training data and any future retention, anything that OpenAI wants to do. That's the client's name and the intimate information about the client's dispute she's paying Halstead and Cole to help her with. All right. Now, when it comes to the ISO 42001 requirements, Annex A control A.7 clause 8.3 requires the organization to determine and document the data used in AI systems, including the source, quality, and the appropriateness of the data, to define controls on data access, processing, and retention, and to verify that data flows are subject to valid legal mechanisms across border transfer, right? That is what ISO 42000 requires. So there has to be these controls in place. There's no excuses for just copying and pasting just blindly into ChatGPT and say, give me a summary. All right. Now, when it comes to the UK GDPR, Article 28 requires a signed data processing agreement with every processor. Articles 44 and 46 require a valid transfer mechanism for personal data leaving the UK. Okay? So the moment Sophie Chen copied and pasted the client's name and substance of their dispute into ChatGPT, that personal data left the UK. Total breach of UK GDPR Article 28, 44, and 46. Now, when it comes to the SRA Rule 6.3, it requires firms to keep client affairs confidential. Submitting client data to a US-based API without these mechanisms is, today, an active breach of 3 regulatory layers simultaneously, right? So you're just breaching 3 things off the bat straight away just by copying and pasting client information in ChatGPT to just summarize or give me the key points. Straight away, 3 breaches at 3 different levels. Okay, so we need to understand what the gaps is here. See, there's no DPA, there's no transfer mechanism, there's no privilege protection. All right. Now, OpenAI, US-based company, they do not engage under the UK GDPR law. All right. Now, what's happening with Halstead and Co in this scenario? Just by Sophie Chen copying and pasting the client information into ChatGPT, you've got data that leaves the US from the UK to the US, but this data has not passed through any UK international transfer agreement, and also the UK addendum to the EU SCC, with no actual documentation in place by the firm. Fee earners are able to submit client documents to commercial LLMs. There is no transfer impact assessment. There is nothing. There is no documented rule forbidding them from doing this. So the privilege waiver risk is current and unmanaged for Halstead and Co. And any legal firm that's actually utilizing commercial LLMs in this way, you're also at risk. Now, the fix for this is another document, and it establishes an AI data governance register. Okay. Now, this document, for each AI system's data flow, it categorizes the client data that can be submitted and what is prohibited. For example, identifiable client names in sensitive matters, which should be a no-brainer. The data classification rules and the transfer impact assessment for every cross-border flow. A signed DPA is mandatory before any personal data enters a cloud AI tool, whether that is the ChatGPT chat front end or Copilot integrated into Outlook or Word. The register is reviewed annually, and whenever there's a vendor change, the data is also changed in the policy. All right. And again, like always, with this module, I'm providing additional value by providing you with 3 templates for each one of these gaps. Now, we go on to gap 7, AI transparency and disclosure. Now, for Halstead is sending AI assistant correspondence to clients without disclosing that AI is being used. Now, this breaches the SRA's February 2026 transparency guidance and exposes Halstead to a regulatory finding that is straightforward to evidence. Every email Copilot helped draft is a record. Okay, so let's look at this problem here. So you have every email at Halstead Co. Fiona drafts with the Copilot assistant is evidence of undisclosed AI use. So you got the Pemberton Capital, which is the Halstead Co.'s biggest client. A client already asking about AI governance receives correspondence drafted this way every week. So they receive information from Halstead Co. that has been drafted by Copilot. Now, when Pemberton's compliance team eventually asks Halstead to see the firm's disclosure statement, the absence of a disclosure statement is the most visible gap in the procurement file. Okay, now let's look at what ISO 2001 requires. Now, Annex A, Control A.8 requires the organization to document its policies and procedures for providing transparency about the use of AI, including audiences to whom AI use shall be communicated, the format of disclosure, and the points in the AI lifecycle at which disclosure shall occur. So that's what ISO 42000 requires. Now, when it comes to the SRA code rule, that is 7.1, and the SRA AI guidance from February of this year, February 2026. SRA 7.1 requires clients to be given information in a way that they can understand. The SRA's February 2026 AI compliance tip states that it should always be made clear to clients where they are interfacing with AI. This applies today to every AI assisted communication the firm sends, not a future state once governance is mature. It needs to start today. Now, the firm is in breach, and I say the firm, Halstead Co., in this scenario, is in breach of the SRA's guidance today because Copilot assisted emails to go to clients daily without any disclosure. The actual Leap AI, which is a legal assisted billing tool and something along those lines, but it's an AI tool specific to legal firms. So the Leap AI assisted billing narrative goes to clients without disclosure. The use of ChatGPT assisted research summaries inform advice without disclosure. None of these communications contain a transparency statement. And the firm is currently in breach of the SRA's published AI guidance. And that's the one from February 2026. And that breach is documented in the firm's own email server. So that's crazy. However, again, I have a fix for you. And that fix is another document. And that is the standard disclosure statement inserted into client agreement letters and AI assistant correspondence in language approved by Priya, who is the COLP in the scenario, and is countersigned by Jonathan. So Jonathan Halstead, who is the managing partner of Halstead Co. Now, the disclosure covers what categories of work the firm uses AI for, the human review commitment, the data classification rules applied to AI inputs, and the client's right to request human-only delivery. This statement is reviewed annually, all right? And when we go into that into more detail, you will also get the template that goes with that. So those are the critical gaps. Now I want to talk about the high severity gaps, all right? Now, when it comes to the high severity gaps, and let's talk about the difference. So the difference between critical and high. So a critical gap means the firm is in current breach of a regulatory obligation and cannot achieve certification. That's critical. You're not going to be certified. A high gap means the firm is in a current significant compliance weakness and will be unable to evidence the requirement at audit. The 4 gaps below are not less urgent than the 5 critical gaps that we've just covered. Now, these gaps are gaps that can be fixed over the next 60 to 100 days, while the critical gaps must be closed within 30 days. All right? So, critical gaps, they must be addressed and closed within 30 days. And then you have the high risk, You're working towards it. These are the gaps that we're just going to cover now, the high gaps. All right. So the first high gap is the AI system register and prompt. So currently for Halstead and Cole, there is no central register for AI systems in use at the firm. So fee earners like Sophie Chen have embedded AI prompts into browser bookmarks, email signatures, one-off word macros with no version control, no sign-off, no visibility for the IT team or Priya, the COLP. So the firm does not know what AI tools it depends on and cannot evidence that the tools it does know about are managed. Okay, so let's look at the scenario here. So we've got Marcus. Marcus, he's the head of IT, and he's been asked to list every AI tool in the organization. He produces 4. Now, the firm also sends out an anonymous staff survey, which reveals 10 more. This includes 2 browser extensions, an Excel add-in, and a personal ChatGPT Plus account paid for on a fee earner's personal card. None of the 10 is in any register. None has been risk assessed. None has a DPA. All right. That's the gap within the scenario under this high risk gap that we're talking about now. Now, what does ISO 1 require? Okay. The clause 7.5 requires the organization to determine and to provide the resources needed for the establishment, implementation, maintenance, and continual improvement of the AI management system. So documented information shall be maintained to the extent necessary to support the operation of the AI management system and to retain evidence of conformity. Right? So that's what ISO 24001 requires. Now, when it comes to the SRA rule 2.1 and the UK GDPR Article 30, this is what they require. Now, for the SRA Rule 2.1, it requires effective governance arrangements. The UK GDPR Article 30 requires a record of processing activities covering all personal data processing. So AI tools processing client personal data are processing activities that must be recorded, and the record doesn't exist within Halstead & Co. So let's look at the gap. Staff embed AI prompts in a browser bookmark and emails. There is no central prompt library. There is no version control. When a vendor updates its model, prompts that worked yesterday may not work tomorrow. The firm has no procedure for tracking prompt changes, no record of which prompt produced which client output, and no ability to reproduce any high quality results. That's the gap. How do we fix that gap? Of course, you have an AI system register and prompt repository. All right, another document. But this document catalogs every AI system. So system ID, vendor, version, deployment date, system owner, data classification, permitted, last review date, current status, and it's accompanied by a prompt repository which holds the approved prompts with version history, the system they associate with, and the review approval. Now, any new tools cannot be added to production without an entry into this register. So that paralegal that took out a pro account on their car, on their own card, and they use it for, no, that comes to a stop straight away. And again, when we go into more detail on this gap, I have a template for you guys to use. Gap 5. So we're talking about the AI system lifecycle management. Now, when vendors like OpenAI, Microsoft, and in terms of the legal industry, Leap AI, when they release a new model version, the firm, Halstead & Co., has no procedure for assessing the update, the regression testing for the change, or informing affected clients. The firm's risk profile can shift overnight without anyone actually noticing. All right. So let's look at that in a little bit more detail with regards to the scenario. So you've got OpenAI retires ChatGPT 4.0 on a Tuesday at about 6 a.m. US Pacific time. Now, by Tuesday lunchtime, UK time, by the way, Sophie, paralegal, is using ChatGPT 5 without actually knowing it. The prompts she has refined over 6 months behave differently. The contract review tool outputs have changed. Nobody at the firm has been notified, and no procedure exists for assessing the change. So Sophie, she's coming in on a regular Tuesday using ChatGPT how she normally does, and doesn't actually realize that OpenAI has released a new model and has automatically made that model default the moment people open up the login and want to use the chat model. Sophie has no idea. And now the outputs that she was getting from the prompts that she's been using over the past 6 months, the results are different. And there is no mechanism within the firm to assess these changes, even to be alerted that there was a change in the first place. Now, what does ISO 42001 require? Clause 8.2 requires the organization to implement a documented process for planning, designing, developing, testing, deploying, operating, monitoring, and retiring AI systems, hence lifecycle. The standard is explicit. Lifecycle management includes the management of changes to AI systems, including vendor-side model updates. They can't put that any clearer in terms of that clause. Okay, now let's look at what the SRA rule 3.2 requires. A fee earner who believes they are using ChatGPT 4.0 but is actually using ChatGPT 5 is, in regulatory terms, operating outside of their competence. And that's harsh, but true. They have not assessed the new model's failure modes, and the firm, in terms of this scenario, Halstead Cole, the firm has a duty to ensure fee earners, in this case Sophie, know which model they are using and what its limitations are. Again, plain and simple. Know what you're using and know what the quality of the outputs that you're going to get from what you're using. All right? So, you've got Marcus. Marcus is the head of IT. He has no alert configured for vendor model updates. He's not one like me that likes to keep up to date with the latest AI models and the latest AI news. Nevertheless, the procurement function does not flag an AI model change. So again, Marcus has no idea. There is no procedure for regression testing the change against a known set of expected outputs. Again, that can't take place if Marcus doesn't even know there has been a model change in the first place. And there is no client-facing notification when a change in a tool or model affects the work the firm is producing for them. Again, how can they if Marcus doesn't even know that the model has changed? That's a huge gap. How do we fix that? Yes, you've guessed it. Another documentation, a much needed one. Now, this documentation defines the firm's life cycle stages. Again, plan, acquire, onboard, operate, update, decommission. The procedure requires vendor change notifications, regression tests suites, impact assessments, sign off before redeployment, and client notification where change affects the work produced. Okay. The procedure is reviewed annually and after every material vendor change. When we go into that gap in more detail later on in the modules, I also have a template for that. All right. Now we're looking at gap 8, and this is responsible use and human oversight. All right. Now, you have AI outputs are used by staff without defined human in the loop review step or sign off requirements. What that means is that if we jump back to this case, jump down to page 4, you have 2 lawyers that use ChatGPT. They put in one prompt to draft a court submission, which they submitted as verbatim. All right. But the AI generated faulty and it contained fictional citations. All right. So totally fabricated the information it provided. This here is what can happen. So you have AI outputs that are used by staff, so by paralegals, without a defined human in the loop review step or a sign off requirement before things are being submitted to court. All right, so let's look at the scenario. You have Sophie, paralegal, using ChatGPT 4.0 to generate a summary of recent case law on a property dispute. All right, so that's the scenario. Now, the summary includes 3 case citations. Sophie does not check them against the primary source. There is no procedure requiring her to do so. The summary is incorporated into a skeleton argument and then filed. One of the 3 citations was fabricated, and that can result into this lawsuit. All right. Now, follow the same pattern as we always do with all the gaps. What does ISO 42001 require? The clause 9.1 requires the organization to monitor, measure, analyze, and evaluate the performance and effectiveness of the AI management system. This includes monitoring the operation of the AI systems, the rate of human overrides and AI outputs, and the effectiveness of human review procedures. The oversight requirement is mandatory. It's not an aspiration, it is mandatory. It must happen. You cannot submit anything that's AI generated to court as verbatim without it being checked by a human. Now, what does SRA rule require? Now, for the SRA rule 3.2, competence, and rule 3.3, supervision. So the SRA's competence and supervision rules require fee earners to verify AI assisted work before it constitutes a client deliverable. All right. See, when it comes to that court case, that judgment makes it clear that a court will not accept AI told me as a defense. The duty of verification is the fee earners and the supervisors, and is okay. The gap in a scenario is that Halstead Cole has no procedure specifying which AI model requires a second pair of eyes review, which can be used unsupervised, what the review checklist is, how human override decisions are recorded, or even how AI related incidences are reported as well. Fee earners like Sophie make decisions individually, inconsistently, and without any record. How do we fix this problem? Or how do we close this gap rather? We have an actual document. That is a human oversight and AI output review procedure. All right. Now this document, what it does, it defines which AI outputs require human review before client delivery. The review checklist, so, citation verified, logic checked, bias flagged, data classifications confirmed, right? So that's what the review checklist. You have the recording requirement for human override decisions and the incident reporting procedures for AI related errors. And of course, you got the monthly review override rates per system. Again, I have a template for you guys to actually download and use. Okay. Now, I have got a disclaimer here. Now, this document shall be reviewed by a compliance counsel before any form of adoption. My template is, call it the wireframe of the actual document. All right. Whether it's the legal document or compliance, these documents has to be, before you put anything in production, reviewed by the actual professionals itself. I'm giving you the actual skeleton of what these documentations actually look like and the information that it's saying is required within it so that you're compliant. Okay. Then we're going to move to the gap 9, and that is the supply chain and third party governance. All right. So what is that? So you have the firm, Halstead Cole, has not reviewed the terms of service of any AI vendor for its data retention, model training opt-outs, or sub-processor agreements. There's been no data processing agreement in place, and the contract review tool has a vendor nobody at the firm can name. The supply chain is unmanaged. All right. So what does that really look like with regards to the actual scenario? So you've got the commercial property team at Halstead Cole using a contract review tool. All right. Now, Priya, the COLP, asked the team for the vendor name, and the partner cannot recall. When Priya asks Marcus being the head of IT, he can confirm the license is paid but not the underlying vendor's data processing terms. So the firm is actually processing client contracts through an AI tool whose data handling practices has never been assessed. Now, what does ISO 42001 require? According to its clause 8.4, it requires the organization to control externally provided processes, products, and services that relate to the AI management system. This includes AI vendors. The standard requires documented supplier assessments, defined controls over the supplier relationship, and ongoing monitoring of supplier performance. That's the ISO 42001 requirements. What about UK GDPR? Okay, for the UK GDPR Article 28, it requires a binding contract with every data processor. Article 32 requires appropriate technical and organizational measures. The ICO has issued clear guidance that AI vendors processing personal data are processors and require a DPA. Submitting client data to a vendor without a DPA is a current breach of Article 28. So this is UK GDPR standards. This is what they expect. Okay. Now the gap in the scenario is that in Halstead Cole, OpenAI's terms of service has not been reviewed by the firm's data classification rules. The Microsoft Copilot that they've got enabled, its PA status has not been confirmed. And then you've got the legal tool that they use, which is the Leap AI. Its subprocessor list is unknown. The contract review tool vendor is unknown. The firm has no register of suppliers relationship, no review schedule, no process for adding a new AI vendor to the supply chain. A huge gap. However, that can be fixed. And that can be fixed by, yet again, another document. And this document catalogs every AI vendor, the vendor name, the DPA status, the transfer mechanism in place, the data retention period, model training opt-out confirmation, sub-processor list, last review date, and risk rating. Now, the third-party checklist is a pre-onboarding questionnaire that that must be completed before any new AI vendor is added to the business. The register is reviewed annually and on every vendor policy change. That's the fix. That's what closed the gap. So you've got 9 controlled documents, and which I like to call the master inventory. All right. So every gap in this module closes with a controlled document. Now the table I'm going to show you below shows you what these documents are that we've just covered. So you've got from gap 1 to 9, and these are the documents that closes these gaps. Okay. So you've got the AI policy and management direction, and that falls in line with the ISO clause 5.2 and 8.2. In the scenario, the owner of this is Jonathan as the partner in terms of the sign, in terms of signing it off, and then Priya, the COLP, the owner, ensuring that is implemented. Okay. The closing gap 2, you've got the AI roles and responsibility register. That satisfies the ISO clause 5.3 and 8.3. And the owner of that is Priya as the COLP. Then you have the AI systems register and prompt repository. That closes the gap 3, falls under the clause 7.5 and 8.4. The owner of that is going to be the head of IE, which is Marcus Webb in the scenario. You've got gap 4, and that is closed by the AI risk and impact assessment register. That satisfies the ISO clause by the COLP, Priya in this case. You've got gap 5, which is closed by the AI system lifecycle management procedure. That satisfies the ISO clause 8.2 and 8.6. The owner of that again would be the head of IT in the scenario, which is Marcus Webb. You have gap 6, and that is closed by the AI data governance register and transfer impact assessment document. And that satisfies the ISO 8.3 and the A.7 standard. The owner of that would be the COLP. In case of the scenario, that is Priya, as well as the head of IT, which is Marcus. You have gap 7, and that is closed by the A transparency disclosure statement, satisfying the Annex A.2 and A.8, owned by Priya as she is the COLP. Gap 8 is closed by the human oversight and AI output with 9. That is owned by the senior partner. Okay. In the scenario, that would be Jonathan. Then we have the final gap, which is gap 9, and that is closed by the AI supplier governance register, plus which also includes the third party checklist, satisfying clause 8.4 and A.10. And in the scenario, that is owned by Marcus Webb, who is the head of IT, and Priya, who is the COLP. Okay, so these gaps needs to be closed before any co-pilot is switched on or Leap AI is distributed throughout the firm for fee earners to utilize. Okay, so now we've covered everything in module 1. 2, we're sticking with the same throughout the whole module, so there's 10 modules. We're going to be sticking with the scenario of Halstead Cole. And so at the end of our module 2, in the next video, Halstead Cole will have a complete inventory of the firm's 9 AI governance gaps with severity ratings and a document that closes each one. They'll have a named cast of stakeholders, so Priya, Jonathan, Marcus, and Sophie, each with a defined role within the remedy of fixing, closing these gaps. A mapped understanding of the 2 triggers driving the C-suite to act: regulatory exposure and client procurement. A master document register that names every controlled document the firm will produce across modules 3 to 10.